I'm the Executive Director of the Downtown Development Authority, and welcome to this webinar. We are thankful that Gunster Law Firm has stepped forward to give us some great guidance and help all of you who are business people in our community apply and navigate the federal assistance program right now for COVID-19. The goal of this webinar is to answer your specific questions. Many of you submitted questions. I've spoken with several of you, I'm sure, on this webinar about issues that are affecting your ability to maximize your benefit or even to access a benefit, particularly through the Paycheck Protection Program. Also to discuss landlord-tenant issues and any labor law issues that you might have right now as we try to navigate this process. Following this webinar, our goal is that we will, if you are a business within the DDA district, is that we will be able to have Gunster assist your business in accessing funds, in navigating issues related to labor laws or landlord-tenant issues, and that will be covered up to a specific amount. We can talk later offline about that, and we're just looking to do what we can do to help businesses. So with that, I'm going to turn it over to Joe, and we'll go from there.
Yeah, thank you, Raphael, and thanks everyone for being here. First off, I just want to clarify one thing. This kind of limited scope assistance Gunster is going to be able to provide under this program with the DDA is really just limited to advice relating to the Paycheck Protection Program. With that said, beyond that, we're of course available to assist with any other issues that might come up, but that wouldn't be part of this this engagement we're doing with the DDA. With that, again, thank you to Raphael and the DDA for organizing this. Also, thank you to all of our participants. We know these are trying times. We really hope the information and resources we present today will be helpful. Really a special thanks to everyone who submitted questions. We got some great questions, which I think will make for really a good and hopefully helpful discussion. So just to quickly lay out what we plan to cover during this webinar. First off, we're going to provide some brief updates on topics relevant to downtown businesses. It's going to include a brief update on the PPP, and also Joe Santoro, our labor and employment lawyer on this call, is going to provide some fairly timely information relating to reopening businesses. We're then going to spend most of our time on a question and answer. We thought this would be most helpful. We had a number of questions submitted in advance. I think we probably have more than enough good questions, but if we have time at the end, we will try to open the floor to questions from participants, just depending on how things are going. Wanted to point you towards some other resources you might want to look up after this meeting. The lawyers of Gunster have really been putting quite a bit of time into developing resources that'll be helpful to the business community. You can find some of these resources by going to gunster.com/COVID-19 or gunster.com/cares-act, or if you can't remember those, which I never can, just go to gunster.com, and the link to our COVID-19 resources is front and center. So that's probably the easiest way to find those resources. I also recommend you follow us on social media. We are updating our Facebook page daily with good COVID-19 content. We also are posting daily updates from our chairman, Senator George Lemieux, just to keep everyone posted on how this crisis is unfolding. We also are on the other major social media platforms, including YouTube, where we are posting videos of all of the webinars and other video content we're doing. And then, of course, after this meeting, please feel free to reach out to any of us if we can be of any further assistance. So with that, just want to quickly introduce our panelists today. First off, Adi Rappoport. He co-leads Gunster's tax law practice. He'll address the Paycheck Protection Program, although our other two panelists will also weigh in on some issues relating to the PPP, as we know that's probably the the topic folks on this call are most interested in. Next up will be Joe Santoro. He's the chair of our labor and employment practice group, and he'll address labor employment issues that businesses are facing as a result of the pandemic. We'll also have some things to add relating to the PPP. And then finally, Bill Perry. Bill's, who many of you probably know, is our firm's CEO and managing shareholder. He'll address landlord tenant law issues that businesses dealing with COVID-19 are encountering. And he'll also chime in, as with the other two, on the PPP. He's had some really practical experience navigating this process, and so can add a lot of value as a result. So without further ado, Adi, can you go ahead and get us started with your initial comments?
Yeah, good afternoon, everyone. I really appreciate the opportunity to speak in front of you today. I know these are very uncertain times, and I hope everyone is safe and healthy and adapting to this new normal. What I've been focusing on the past month or so is the CARES Act, and specifically the Paycheck Protection Program. And what the Paycheck Protection Program is essentially is a tremendous expansion of the SBA 7A loan program. And that loan program is typically available for small businesses. What the CARES Act did was significantly expand what a small business is. And so the eligibility is essentially for any business with fewer than 500 employees that was in operation prior to February 15th, 2020, and make certain certifications under the application. There's also special provisions in terms of sizing, employee sizing for businesses in the restaurant hospitality business, which I know a number of you on this webinar that is the business that you guys run. The main issues that have come up, there's certainly, you've read about the hiccups of rolling out, a $349 billion plus another $310 billion, which was recently expanded program. There's definitely been hiccups for us as advisors in terms of figuring out how to interpret the law. There's been issues for the banks about how to make the loans and what process do they need to have the loans guaranteed by the government. And there's been issues for applicants, for the people on this call, in terms of interpreting, what do payroll costs mean and what information do I need, and who do I include in the calculation of payroll costs, and how do I deal with a lot of issues that we saw demonstrated in the questions that you've provided to us today. So I think we'll have the opportunity during the Q&A to cover a lot of ground in terms of the details of the program. And certainly we're available for follow-up questions after this webinar.
Okay, thank you, Adi. Next up, Joe Santoro to talk about labor and employment and specifically reopening related issues.
So good afternoon, everyone. I'll probably dive a little bit deeper in what I want to talk about during my opening remarks, because what I'm going to talk about is hitting the restart button. And so, like Adi, we've been dealing with the Paycheck Protection Program. We've been dealing with the employment issues that relate to how to get the money. But now that some employers are getting the money, and now that we're looking, perhaps not so much in South Florida early on, but across the country, employers are starting to think about how to restart. A lot of the questions that we're getting in our firm are about making sure that they restart in a way that doesn't create lawsuits. And as you might expect, employment law and employment law lawsuits are probably the biggest challenge in trying to get your business back up and running in a time and under circumstances that no one has ever seen before. Certainly not in my lifetime, and I would expect most people on this webinar. So I wanted to talk to you a little bit about, what do you need to do to make sure when you restart, you're doing it the right way. And if we've given some seminars on the employment issues relating to paycheck protection. I'm certainly happy to answer any questions anybody has about that. We've given some seminars on the Families First Act with the leave requirements and the expanded FMLA leave requirements. certainly happy to answer any questions out that. But what I want to talk to you about is what is the guidance we're getting from the federal agencies about, what we need to do to reopen. And unfortunately, or fortunately, there's a lot of different sources that this is coming from. And the first one I want to talk about is the White House's recently issued guidance for opening up America. And, lucky for you guys, you haven't had to read all of this. we have. And, the White House last week issued some of this guidance. And before I delve into that, I want to tell you why this matters, right? So it's likely that when you guys go back to work and you have your employees come back to work, this virus is not going away. And so what all of this guidance is designed to do is to provide some parameters for you, number one, to safely open and operate for not just for your customers, but also for your employees. But on the legal side, what you have to remember is that, workers' compensation insurance is still at issue here. And so normally, if you have workers' compensation coverage, and I expect all that you do, if you have an employee that gets injured at work, which would include an exposure to a virus, or gets sick at work because of a virus, then that is a claim that would normally be covered by workers' compensation insurance. So you wouldn't necessarily, outside of workers' comp, have to worry about liability for your business. However, there is an exception to the workers' comp standards, and that is where the employer engages in conduct that is, quote, substantially certain to result in an injury or death. And so what we are expecting is that we are going to see the plaintiffs' lawyers that practice in the labor and employment space start to argue that because the employer didn't properly follow the guidance issued by the government agencies, that they are creating a danger within the workplace that falls outside of the workers' comp protection, and probably for which you won't have insurance coverage under workers' comp. So this piece of it, I think, is very important for all of you to start looking at to make sure that you're putting things in place that enable you to be able to say that you acted reasonably and responsibly in setting up protections for your employees when they come back to work. So where does all this come from? I already mentioned the White House's guidance. And if you haven't had a chance to look at that, it's available at whitehouse.gov. And what this does is it requires employers, as part of their reopening plan, to develop policies. We would suggest to you that they need to be written policies on minimizing risks in the workplace, such as social distance policies, implementation of protective measures like temperature checking. I know we had one question about that. It's pretty clear from all of the guidance that's out there now, including the EEOC's guidance, which was updated just today, that it is acceptable and authorized for an employer to take the temperature of their staff on a daily basis to make sure that they're not coming to work while they're experiencing signs of COVID-19 infection. Standards for sanitizing and training your employees on how to remain sanitary in the workplace, travel restrictions and limiting the interactions with your employees in the workplace. Those are all things that the White House guidance says that employers who are ready to reopen need to start doing. So we would encourage you, number one, to read that guidance, take a look at what the basic parameters of your policies need to include. And then the next step for that, and probably the hardest piece of that, is trying to make that fit within your business. So for example, if you're a business like ours, where we have a traditional office environment, there are some things that are easy to do. We can shut down the lunchroom. We can open doors so that employees don't have to touch doors frequently to travel within our space. But if you're a restaurant, well, it's a lot harder to do some of those things. So it's really important that when you're looking at all the guidance that's out there, you have to do so with an eye towards what your business is and how it operates and how it functions. And that's going to be different for every business that's on this call. But the fundamental principles are that you have to have some policies in place. You have to have given some thought on how you're going to allow your employees to come back to work in a way that minimizes their risk and the risk to your customers. And the White House guidance is broken into different requirements at different phases. I won't bore you with that, but when you go and you look at it, you'll see that, as the country gets healthier and as counties have fewer and fewer instances, a lot of these requirements will drop off, hopefully, when you get to phase 3, which we don't know when that's going to occur certainly for Palm Beach County and West Palm Beach. It may be a long time before that happens, but when you get to phase 3, all of these things will go away and you'll be able to operate as normal. The second area that I think you should take a look at is OSHA has issued specific guidance on how to restart your business and be in compliance with OSHA requirements. And those of you that have dealt with OSHA before understand that in addition to the specific things that OSHA requires, OSHA also has what's called a general duties clause in the law, which means that employers have a generalized duty to make sure that their employees are safe at work. And with respect to COVID-19, there's a 50-page guidance memo issued by OSHA on what OSHA is going to expect you to do in the context of reopening your business. And similar to the White House guidance, OSHA says that you have to have in place a protection plan, a plan that is thought through on how you're going to ensure that your employees' risks are minimized. Things like bringing back your work staff in staggered shifts, implementing alternative work schedules to reduce the amount of people that are in your business, restricting employees from using other people's equipment, and putting some measures in place to ensure that common equipment, things that everyone uses, are cleaned on a regular basis. In addition to regular housekeeping practices that OSHA says you should be doing to make sure that your work environment is cleaned and sanitized. Also, OSHA says that you have to implement and create policies on how to identify, isolate, and remove from your workplace people who are experiencing COVID-19 symptoms. So obviously, they've been saying all along, and all the government agencies have been saying all along, that individuals who are experiencing symptoms need to stay home. But what OSHA is saying to employers now is you have to go beyond that and actually, for lack of a better word, police your work environment to ensure that if you've got someone who's sitting in an office who's coughing, you can't ignore it. You have to take some action to ensure that even if those people make a bad decision and come back to work ill, that you're not allowing that to be exacerbated by not doing anything about it. And OSHA says that you have to do that. We did get some questions before this, and I'm sorry, Joe, if I'm taking too long, but there's a lot here. We did get some questions before this about, do employers have to provide PPE, personal protective equipment, to their employees? And the answer is generally no. There is some standards in OSHA that if you are in what they call a high-risk category of business, such as medical providers and people that have regular contact with individuals that they anticipate might be infected with the virus, if you're in that category of business, then yes, OSHA does require that you provide PPE to your employees to ensure that they don't get infected. But there is a little bit of gray area in the OSHA guidance, and that is if you are considered to be what they call a medium risk business, then you might have an obligation to provide PPE equipment to your employees. Well, what's a medium risk business? Well, it depends. They've given a few examples in their guidance, such as people who have regular interaction with people that travel in and out of the United States, or in a business where there is substantial exposure to the public in an area where there is ongoing community transmission. Well, guess what? Palm Beach County right now is an area where there is ongoing community transmission. So depending upon your business and how much interaction the people that work for you have with the community where there is a high rate of infection, you might be required under OSHA, and I emphasize the word might, to provide some measure of protective personal equipment to your employees. So that's something you really need to look at. And then also within OSHA regulation is they split up the types of mitigation measures that employers are supposed to have into place into two different categories. One is like an engineering category for those of you that have been, for example, to Publix, and you've seen that they put those plastic screens up in front of the cashiers. Well, that's something that OSHA recommends as a physical barrier, an engineering solution to minimize your workplace exposure. But there's also a whole separate category of administrative and policy and procedure implementations that they suggest you put in place, similar to the stuff I've already talked to you about, to make sure that you're limiting exposure in the workplace. Now, if that wasn't enough, the CDC has its own guidance out there. And there's one area where I have identified a little bit of a conflict between the White House guidance, between the OSHA guidance and the CDC guidance, and that is on requiring employees who do get sick to provide a doctor's note before they are allowed to come back into work, right? And that's what we've always done as employers. We said, well, if you're going to take 2 days off, you got to come back with a doctor's note. Well, the White House guidance says it's perfectly appropriate for you to ask for that doctor's note, but the CDC's guidance and OSHA's guidance say, well, that may be true, but it may be impossible. And in fact, as you guys all know, the government is discouraging people who are not gravely ill from going to the doctor's office. So is it reasonable for you as an employer to require someone to expose themselves to the risk of going to a healthcare facility to get a doctor's note when they can otherwise feel well enough to come back to work? And the good news is that there is, on the CDC's website, if you're unable to get a doctor's note, they do set forth some standards for employees to make sure they meet before they return to work. And that is, you must be symptom-free. If you've been ill, you must be symptom-free, including no fever, without medication controlling your fever for at least 3 days before you can stop self-isolating. And it must be at least 7 days. That timeline must also be at least 7 days from the commencement of your symptoms. So if you're an employer and you have employees that can't get a doctor's note because they don't want to go to the doctor or because the doctor's unavailable to them, you must at least inquire of them whether they meet those CDC guidelines before allowing them to return to work. Which brings me, again, I'm sorry if I'm taking too long, into the very last category that I wanted to mention to you. That layered into all of this, as you know, is Americans with Disabilities Act and EEOC restrictions on the types of questions that you can ask your employees. Remember that as a general rule, employers are not permitted to make medical inquiries regarding their employees unless there is a business necessity for it, or the individual might pose a direct threat to themselves or to others in the workplace. And so what the EEOC's most recent guidance says is that it is permissible, and this is a big change for most employers, it is permissible for an employer to make inquiries regarding an employee's health condition if those inquiries are limited to asking them whether they have experienced any of the common symptoms associated with COVID-19. So you can ask them, have you had a sore throat? Have you had a fever? Have you had cough? Have you lost your sense of smell or taste? If you're asking those types of questions of your employees, that is permissible, but you can't really go further than that and dig into, for example, without them volunteering it to you, other inquiries regarding whether those people have pre-existing conditions or other things that might increase their risk to themselves or others in the workplace. So that is the backdrop. I know I've talked a little longer than maybe everyone expected, but there's a lot here. And what I would strongly recommend to all of you is that you take an hour or so out of your day when you're thinking about reopening your business and go through these. White House guidance, OSHA's guidance, the Center for Disease Control's guidance, and the EEOC's guidance. They're all available online. If you can't find the links to them, I'd be more than happy to share those links with you.
Great. Thanks so much, Joe. So next up, Bill Perry, landlord tenant issues.
Thanks, Joe. It's Bill Perry here. I'm the managing partner of the firm, so I've been dealing with our own leases as well as our PPP loan application. And I know we received a bunch of questions on lease issues as in the pre-submitted questions. You know, as an overview, every lease is going to be specific, and you have to really review the language to determine if the tenant has any relief available under the terms of the lease. I would encourage everybody to look at your lease and look for a couple things. Look at what your lease maturity is. The shorter the maturity, the more leverage you might have with the landlord to negotiate a deal. Second, I would look and see if there are any termination rights that you may have pre-negotiated into your lease as a result of any circumstances. And that also could create a leverage scenario for you in the landlord negotiations. The rest of the questions we received were more in the nature of default and then who's responsible under the terms of the lease. And Joe, if it's okay with you, I'll defer those until you get to your Q&A.
Well, that
and
sounds great.
Address them as you raise them.
Excellent. Yeah, thank you, Bill. So with that, I think we'll go ahead and get into the questions. As I said, first off, we'll do some questions around the PPP. So Adi, the first one I have for you, really just a practical question. What information should I have ready for the PPP application?
Okay, so yeah, before I answer the question, I just want to clarify that yesterday, if I didn't make this clear, there was news last week that the PPP program ran out of money. And yesterday, Congress reauthorized an additional $310 billion of appropriated funds for this program. So there is now money available. So if your application was in queue, it should get funded, and the banks are required to fund the loans within 10 days of approval. If you have not applied yet, the first thing I would tell you is to, same advice that Joe Santoro gave with respect to reopening your business, is take a look at the loan application online and the instructions and what's required. What you'll find is the application is fairly basic. For most applicants, it'll be pretty straightforward in terms of the required information. The toughest part is substantiating your payroll costs, because that's how your maximum loan amount is determined. So the maximum you can borrow under a PPP loan is 2.5 times your average monthly payroll cost, and it's capped at $10 million. So there is some work you need to do to substantiate what your payroll cost is, and your bank is going to ask for that. And the way you do that is you can pull your payroll records from 2019, so you can use calendar year 2019, or alternatively, the law allows you to use the trailing 12 months ending on the end of the month before you apply. And the other thing is, if you have a complicated ownership structure, understanding who your ultimate beneficial owners of the business are, And there may be different procedures depending on how your business is structured. So if you are a sole proprietor or an LLC that's taxed directly to you, you may have to provide different information than if you are a corporation in terms of determining what the borrowing amount might be.
Great. Adi, the next question is, it's a little longer. It's a pretty straightforward question, but it has a lot of words. But I think it's important to ask it because I would assume is relevant to a number of the participants in this webinar. So the PPP program guidelines state that payroll costs include tips, which is confusing for restaurant and nightlife business applicants, as tips are income that the employee receives from the customer. How do businesses estimate how much money in tips an employee would have made to come up with the amount an employee would have made for purposes of the PPP application? For example, a business pays an employee $6 per hour, and the employee typically earns about $5 per hour in tips. If businesses are paying wait staff and bartenders while the business is closed, they're not including what those employees would have otherwise earned in tips. So how do we account for tips for purposes of the PPP?
So, 2 points. One is in a fully compliant situation, the employee is obligated to report their tips to the employer on a regular basis, on a monthly basis. So all of the employee's tips, in theory, should appear on the employee's W-2 at the end of the year. I understand there's some bleeding when it comes to this kind of stuff, and a lot of employees or service workers take their tips in cash and may not report them completely to their employer. But the point is, you can only request the loan based on what was actually reported.
Huh.
So that's fundamentally how you determine the loan amount. It's based on what's on the W-2 on the payroll records. The next question is, during the 8-week period, you need to spend at least 75% of the loan proceeds on payroll costs, which may include tips. In that instance, I would estimate, because there's nothing inherently wrong with paying somebody more potentially, or estimating what they should have earned based on an average amount during the payback period. So if someone is making, and particularly I'm talking about people making less than $100,000. So if you take in the example, the $6 an hour, and then you're aware, or or based on prior reporting, that $5 an hour is an additional amount in tips, you could pay that as just an additional salary to those people. So there's probably a way to do that, but realistically, you're not going to be able to pay people more than what you based on determining the loan amount. So if you base the loan amount on what was reported, you may not have enough funds to pay during the 8-week period. You may not have sufficient funds to cover what the tip would have been.
That's great. Thank you, Adi. And Adi, I'll address this next question to you initially because it really does relate to the PPP, but I think this is one Joe Santoro may also want to weigh in on. So here it is. Some businesses have shifted employees to part-time just to keep them on payroll and are using them for deliveries, renovation, painting, etc. If those employees are working part-time and being paid part-time wages, can the business still apply for full-time PPP funding since these employees would be working full-time under normal circumstances? And I imagine this is a question of how much you can get in funds versus how much can be forgiven. But any color to add there, Adi?
Well, yeah, I think what I would come back to is that the overall concept of the PPP program is that you will use the money to pay your workers. So, and in fact, the interim final rule that the SBA issued initially on April 2nd requires you to spend at least 75% of the loan proceeds on payroll costs. So if you've severed some employees, furloughed some employees, they're working part-time instead of full-time, the first question you need to consider is, are you going to be able to actually take the loan? Because if you don't have enough payroll costs to apply the loan proceeds to, then you shouldn't be taking the loan in the first place. So there's a a red light, green light question that you have in terms of how you proceed. The other piece of it, as Joe alluded to, is how do I maximize forgiveness of the loan? So the loan becomes essentially a grant if you spend the money on appropriate expenditures. And so you need to spend at least 75% of the proceeds on payroll. Then you can spend the money on rent. You can spend money on mortgage interest, utilities, but your forgiveness gets clawed back if you have a smaller headcount during the 8-week period after you receive the loan compared to some prior testing periods, or if you decrease the salary of people making less than $100,000. There is a rehire exemption, so you could rehire employees or restore their salary by June 30th. But sort of the nature of the question is it makes it difficult for this particular person to take the loan because of how they've handled their workforce. And this is not an unusual situation. I'll pause and let Joe Santoro comment.
Yeah, I mean, I agree with everything that Adi said, but here's something to keep in mind. And we're still waiting. You know, the thing about these laws is every day or two, there's some new guidance to answer questions like these. But keep in mind that what is required is that you pay the employees. It doesn't matter how much the employee is actually working. So it is perfectly appropriate under the PPP for you to pay full-time wages to someone who is only working part-time or frankly, not even working at all. So why would you do that? Well, remember that in order to achieve forgiveness under the loan, you have to spend that money, and they look at the time period from right when the money is funded to you. When the first disbursement is made, you have to spend over that 8-week period at least 75% of that money on payroll for it to be forgiven, for any of the loan to be forgiven. So you're going to have to do that. And that might mean paying people more for part-time work than you normally would, paying them their full average compensation had they been working full-time during that period. It's perfectly acceptable to do. And in fact, I think contemplated as part of this law that you're going to, despite the availability of work, make sure that employees, at least for that 8-week period, are receiving full compensation.
And before we move on, I think Joe Santoro's comments speak to the main criticisms that you're hearing and reading about relating to the way this program operates, and maybe some of the frustration you might be feeling. You know, some of the criticisms are that this 8-week spending period is too limiting because we don't want to pay our employees not to do anything. We'd rather use the money in a later period when the economy reopens and we have customers. We'll need the employees to come in. We'd rather pay them then than now. The other criticisms are that the 75% requirement is too strict. So, should it be 50%? And there's some discussion, there's lobbying being done to loosen that restriction, because then that would give more flexibility to businesses like yours to maybe pay rent or satisfy other permissive obligations. And the other thing you're reading, there's been a few stories in the press, including CNBC this morning, that some employees would prefer to get government benefits than be on your payroll because of the additional enhancement in unemployment that the CARES Act provides to the states. So there's a lot of cross currents in terms of the policy here and how this helps small businesses.
Great. Thanks, Adi. So here's an interesting question. My understanding is that under the PPP, 8 weeks from the receipt of funds, businesses are required to have everyone back at work with full-time pay. This is highly unlikely. What if this doesn't happen? And so, Adi, I guess the first question is whether this is a correct understanding of what the PPP provides, but then moving on to the practical considerations identified.
Yeah, I mean, there's this sort of no man's land where you borrow the money with full intention to rehire your workers, and the loan is funded, and maybe you don't want to do what Joe Santoro is rightfully advising you should do, which is you got to pay people even if it means that they're staying at home. So the question is, what do you do? And I think there's, in my opinion, two options. One is, consider whether you actually take the loan. And number two, consider repaying the amount that you don't use for the permissible cost. If you're not going to meet the payroll requirement, there's not a lot of guidance. And Joe Santoro made the point that, every day we're hearing something new. So the money is supposed to be used for a very specific purpose. And if in that 8-week period, you can't use it for that purpose, you need to think hard about what you're going to do with that money, because you don't want to be caught as sort of a gotcha story, either in the press or, by the government, God forbid, that you did not use the loan appropriately.
Great. Thanks, Adi. And here's more of a practical question. And I know Bill Perry mentioned he might want to weigh in on this one as well. So do I have to fulfill additional requirements by banks to apply for PPP, such as opening a checking account or whatever other mandates the banks might put out there?
Yeah, I'll start at D and maybe you can chime in. Well, the answer is yes. I mean, the first thing is you need to find a bank that will facilitate and make your PPP loan. The initial guidance we were giving to everybody was go to your existing bank. Most of the national banks, the large banks, were requiring that you have an existing depository relationship, a DDA, a demand deposit account, and an existing credit relationship, or they weren't even taking your application. There are some smaller banks that are preferred SBA lenders that were taking on new customers. In those cases, you don't need to establish a lending relationship, but you will need to open a deposit account to receive the funds. And actually our practical advice is, even if you're going back to your existing bank, you still want to open a new depository account to receive these funds, so you can later account for each and every expenditure from that money and not have it commingled with your other operating account funds. So the answer is yes, but it's probably the more important guidance is make sure you've got a bank that's actually going to process your application in a timely way, and yes, you will need to have a deposit account to receive the funds.
Great, thank you, Bill. Adi, do you have anything to add there?
Yeah, just, I would certainly keep the lines of communications open with your banker in terms of what information they need. One of the challenges is when you start a new relationship, there's know your customer requirements that the banks need to follow. So there's some additional hurdles in getting an account opened at a bank where you don't have an existing relationship. So your best path forward is still with your existing banker, and be on the phone with them and see what information they need, and hold them accountable to helping you through this process.
Great, thank you, Adi. So now I think we'll move on to a few labor and employment questions. So questions for Joe Santoro. And Joe, this is one you touched upon what questions are and are not permissible to ask employees. But this one, I guess, presupposes that a business owner knows some information about their employees. We know older individuals, particularly those with underlying medical conditions, are at more risk from COVID-19 than younger people or people without these underlying medical conditions. May I have different policies for older employees in relation to who gets to come back to work or other protective policies? Similarly, may I have different policies for people with medical conditions that increase their risks from COVID-19?
So the short answer to that is no. As an employer, it is not your obligation, and in fact, I would suggest to you that you may violate the Americans with Disabilities Act if you impose upon your employees different terms and conditions of how they're going to return to work. So you can't basically tell an older worker, you can't come back to work because you're at risk, or you can't tell someone who has some sort of pre-existing condition, a respiratory disorder or something like that, you can't come back to work because you might get sick. So you cannot impose that upon them. However, if an employee who is older or in a high risk group comes to you and says, I don't want to come back to work, or I need to come back to work under different terms than everyone else, you might conversely have an obligation under the ADA to provide them a reasonable accommodation so that they may end up with a different schedule, different work duties and the like because they have that condition. But it has to be a request that comes from them and one that you, under the law, would be obligated to accommodate for someone that had a disability.
Great. Thank you, Joe. The next one, I think this is something a lot of employers have been doing, but to really focus on the legalities. Can an employer reduce pay of employees to save costs during the pandemic? And are there any pitfalls that the business owners should be aware of in connection with reducing pay?
So I'd answer that one, Joe, in two different buckets. One of them is just in general, not considering the PPP loan. And the answer is sure. If you have circumstances which are requiring you to save costs, it is not only appropriate, but somewhat common today for employers to ask employees to take pay cuts in order to maintain their job. As long as you apply that in a uniform, non-discriminatory way, it's perfectly appropriate to do that. However, if you've taken a PPP loan, remember that one of the measuring criteria for forgiveness is, have you maintained your employees' compensation levels at an amount that isn't substantially reduced? And what the standard under PPP is, have you reduced the employee below 75% of what their normal compensation was? If you've done that, then that will impact your amount of the loan that will be forgivable. So the answer is yes, you can do it. If you've taken a PPP loan, you need to be careful about doing it because it might impact your forgiveness.
Great. And this is kind of an open-ended question, but I think it's a good one. I've heard about a new federal law relating to paid sick leave. What's that all about? What are the key things I need to know as a business owner about that new law?
I suppose that's for me.
Yes.
The first thing you should do is go to gunster.com and pull up the guidance that we have issued on this new federal law. The law that's being referred to is the Families First Coronavirus Response Act, the FFCRA, which was the first piece of legislation passed in response to this pandemic. It has two basic requirements, most of which have already been met by employers that are covered by it. One is that you provide employees who have a qualifying reason up to 2 weeks of paid sick leave, but the second, including leave for childcare needs. But the second thing that it did was it amended the FMLA to allow employees who have childcare needs to take time off under the FMLA and receive a portion of their regular compensation while they're on this leave for a longer period of time. So it's a complicated law. It's a seminar in and of itself. But if you want to understand the basics, go to gunster.com, and there's a really good white paper on it that explains the basics of the law.
Great. Thanks very much, Joe. Now, we just have a few minutes left before our end time, but I did want to ask a few questions, Bill, relating to landlord tenant issues that some of our businesses are facing. First off, can a tenant lawfully suspend payment of rent and other amounts payable under a lease during the COVID-19 pandemic? What rights does a landlord have if tenant stops or reduces rent payments? And Bill, I know you talked about how aside from what formal rights a tenant might have, where we are in the lease term might have some impact on how much leverage a tenant has. But how does this situation play out under most leases you see? I think you're muted, Bill.
I was. It was a brilliant statement. Nobody heard it. So I'll put my cautionary statement back out there that it really depends on the terms of your lease. But if I'm making general statements, my first general statement is almost all leases were drafted by the landlord, and the landlord is not inclined to give a lot of circumstances where you don't have to pay rent. So the more likely answer is no, that your lease doesn't give you any kind of automatic relief for non-payment of rent, which then leads to your second question is what rights does the landlord have? Again, dependent on the terms of the lease, the landlord probably has a bunch of rights, legal rights, including eviction and including acceleration of the balance of the rent due for the term of the lease. His acceleration right is offset by his obligation to mitigate, his or her obligation to mitigate their damages, but it is still a pretty significant financial remedy that most commercial leases have. However, our governor has put an order in effect that stays residential evictions, and our Supreme Court and the courts of Florida aren't really processing commercial evictions at the moment. So as a practical matter, can the landlord evict you right now? Maybe not. Can he get into court and get anybody's attention? Maybe not. But you still have the financial risk of the acceleration of remedy, acceleration of the rent. That is a pretty significant financial hammer for most tenants. Again, review your lease. The landlord's remedies will all be outlined there in the default and remedy clause of the lease.
Thanks, Bill. And and I suspect that the good advice that the folks need to review their leases and understand what those leases say applies to several of the other questions we have in this area. But there's one that what if a tenant's obligations under closure orders issued by governments are inconsistent with obligations under the tenant's lease?
Excellent. Well, that's the tenant's obligations, right? So I would say there's sometimes in retail leases, you have a stay open requirement. Yeah. You can't go dark in addition to pay the rent. I would think either force majeure arguments or including the governmental shutdown order would relieve you from the stay open requirement. And frankly, you'd be a really stupid landlord to litigate that issue. Right? I mean, that's just not where you need to be right now. But I'm not sure the same closure order relieves you from the obligation to pay rent. Again, depending on the terms of your lease.
Great. No, that's very helpful. And Raphael indicated to me, I think it is a good idea if we open up the floor for any questions from folks who are logged on. Unfortunately, I think we've had a very productive webinar, but we only have a few minutes left. Hopefully, we can address at least a couple of questions. And Raphael, how do you want to facilitate questions from the group?
Thanks, Joe. And right away, before we lose everybody here, I want to thank the team at Gunster for doing this. It's been a really great help and a very informative session. And I hope everybody who is logged on to this webinar has gained something out of this. And remind you, if you are a business in the downtown district and you have a challenge with the Paycheck Protection Program, we would like to allow Gunster to help you with that. So I would suggest you reach out to the DDA. You can find our contact information on our website, downtownwpb.com. You can reach out to one of us directly, or you can email us at info@downtownwpb.com. So what I would suggest while we have a few minutes is if you'd like to ask a question or you have a specific comment related to the discussion today, if you type it into the chat and we'll recognize you. I just think that'd be an easy way to do it rather than have everybody sort of go at once. So why don't we try that? Is there anyone with a specific question they'd like to ask the panelists?
Yes, I have a question.
Go right ahead.
Can you guys hear me?
Yes, we can.
Okay. So my name is Judy. I'm small business owner. I have a small commercial space, Elite Bookings, Florida. And my question is, what happens if the PPP application is denied? Several grants from the governments are denied for small businesses. What can we expect of how that looks like for us as a small business being shut down for 2.5 months? Hello?
Anybody want to weigh in on that one?
So this is Bill Perry. There, in addition to the PPP program, which is where a lot of the interest is, there are a variety of other small business lending and grant programs, both through the state of Florida, through the Department of Economic Opportunity, and through the SBA, including the disaster loan assistance. Some of those are not as restrictive in the use of the funds as the PPA program is. And they're both the the Florida DEO actually has smaller amounts available, which may be sufficient to carry a small business for a month or two. So I would encourage you to look at both those sources in addition to the PPP loan that we talked about here.
Yeah, I would add one item. There's, in addition to additional funding for the PPP loans, the extension yesterday also provides additional fundings for economic injury disaster loans, which can be used for working capital and potentially other needs. It comes with a $10,000 grant, and you can borrow $200,000 without providing a personal guarantee. You can borrow up to $2 million if you provide collateral. So to Bill's point, there's other loan programs that you should explore.
May I ask a question?
Please go right ahead, Andrew.
I submitted a question earlier about independent contractors. I'm a real estate agent in West Palm Beach, and the PPP loan doesn't fit my needs because I don't have any employees. But for the economic injury disaster loan, how is that going to be working for independent contractors?
So your business through which you operate, whether it's an LLC or a sole proprietorship, could be an applicant for an EIDL loan. That it's not based on payroll costs or workforce. So what you need to show is that you've been impacted by coronavirus, and so that might be an avenue for you to pursue. And you don't need to go to a bank for an EIDL loan. The EIDL loans are funded directly by the SBA, and there's a portal on the SBA website where you can submit an application.
Very good. Thank you very much.
And next,
I have a question.
I have a question.
One moment, we're going to try to go in order. I think Debra Jesme.
Yes, hi. Can you hear me?
Yeah.
Basically, I put in my paperwork a long time ago, the first day that it was approved by Congress. And I'm still waiting on one of those among many people that are still waiting for fund. A mom and pop operations. I lease spaces for beauty in the beauty industry. So obviously I was a non-essential business that was closed. And as a result, I'm still liable to pay the rent and expenses and everything else that goes along with it, which I am right now scraping to do because I'm a responsible person and that's just in my nature. But by the same token, it's draining financial income that I wasn't, nobody was expecting. So my question is, I think Adi, am I pronouncing it right?
Right.
Had mentioned that there's a percentage of the funds that are going to go towards people like us that the payroll protection does not apply to me or any other mom and pop that would cover those expenses. Is that what I'm hearing? There is a percent allowed it to people like us?
Well, I was making slightly a different point about how there's, businesses that are considered underbanked. They don't have a banking relationship, and Congress made funds available for those types of businesses. It sounded like to me like you've already applied and have not received your loan yet. Has if the loan's been approved, the bank has 10 days to fund your loan. Now, there might have been a hang up because funds ran out last week. So I would be on the phone if I were you, calling the bank and saying what the status is of the loan getting funded. You're on mute.
Yeah. The loan was, I sent it directly through the SBA because that's what I was told to do, as I never have applied for any kind of financing. So I sent it directly to SBA because at the beginning there was no information. Everybody was just scraping to find out how we were gonna manage, and the information was just in pieces. Now it's more organized, where the city has a link where it explains to you. And that was one of the suggestions that I gave, to put everything in a link for people like me that didn't know the process, or, you know, we were all lost. So in essence, my question is, if I went directly through the SBA, am I going to hear from them? Or, because again, there was no map, no guidance, no nothing.
Yeah, so what you probably applied for was an EIDL loan. If it was directly through the SBA. I suspect you will hear from them, because that's another program that was underfunded, and they were severely limiting how much money they were advancing and loaning to businesses. That may loosen up because of what happened yesterday. But I don't have specific, knowledge about, the timing. If you receive confirmation that your application was submitted, it'd be hard for me to think they'll reach out to you because they're so overwhelmed. So I think you need to keep following up to the extent you can.
Yeah. Joe, do we have time, or are we about wrapped up?
Yeah, I probably have time for one more question, and then you should probably do your closing remarks.
Sure. I think Thierry Bode.
Oh.
Let me try to unmute Thierry.
Hi. Yes, I am on mute. Thank you very much. Thierry Bode from Pistache. Can you hear me?
Yes, sir.
Okay. So we received our PPP and trying to figure out how to use it. One of the issues we have, like a lot of people, that we're probably not going to need everybody. But even if we're trying to rehire everyone, some of our employees have either relocated or found other jobs in grocery stores, etc. If I wanted to be able to reach that 75% threshold, can I pay the employees that are able to come back to work more than what they were making in order to reach that 75% threshold?
Thank you, Thierry, for that question.
That's an excellent question, Terry. Well, you have two issues. One is you might be able to pay them more, but there are two tests that you need to meet. So there's two questions. Did you apply 75% of the funds to payroll? And that may get you to 100% forgiveness. The other issue you have is just a headcount test. So you're counting full-time equivalents. To the extent you're not at 100% average full-time equivalents like you were in prior testing periods, then your forgiveness might get clawed back. But your question is at the heart of what we would like additional guidance on, in terms of how do you apply the proceeds? Because a related question is, can you apply the proceeds to a payroll period that ended before you got the money, but the payroll payments due after you got the money? And is that an appropriate way to spend the money? So there's a lot of open questions. Yours is a very good one. I don't know if Joe Santoro, you've encountered this or have a different or better answer.
No, I've certainly been asked the question, and the best advice we can give you right now is try to hire more people. And I've had clients hiring their family members because they got stuff for them to do. It may not be the normal job that people that had left were doing, but you're putting someone on the payroll and you're paying them, hopefully legitimately, of course, to do something for your business. Also keep in mind that if you've had employees that don't want to come back because they're making more money on unemployment than you were paying them, they don't have a choice. So one of the conditions of receiving unemployment is that you do not otherwise have work available. So what we've been counseling clients to do is document it. Send them a letter saying, hey, we got some funding through the PPP program. You're hired again. We have a job for you, and we'd like to start paying you again. They may be unhappy because they'd make more money on unemployment. But that's, the whole idea here is to keep people off the unemployment rolls, to keep the companies, whether they're operating or not, in a position to where they're ready to restart. So I would force your people off of unemployment and back onto your payroll, whether they like it or not. And if you've had people that have gotten other jobs, go hire some people and use them in the best way that you can. If you're able to operate at all, or I've had some clients, I think somebody mentioned it on this call, that one of my clients is a big restaurant. They've had people come in to clean the restaurant. They're servers, and they're working. They're not doing their normal job, but they're working and they're getting paid, and most of them are quite happy to get the paycheck. So be creative. You want to try to keep your head count as high as you can. And if you can, there's people out there looking for work. So I'd say hire some new people.
Okay, with that, I think we're out of time. I want to thank again Joe Chase, Adi, Bill, Joe Santoro. We really appreciate the guidance today, the advice. And again, I'll remind everyone, those of you that remain here, if you're a business in downtown and you feel that Gunster can help you navigate some of this Paycheck Protection Program application process, please reach out to the DDA, and we will put you in line to get additional services from Gunster. With that, I'm done. Joe, if you want to sign us off, any last comments? Joe Chase.
Great. Yeah, well, thank you, Raphael, and thanks to everyone for participating. Hopefully you found it helpful. I also want to thank my colleagues for making time. Really, I know this was really good, useful information, and everyone appreciates it. So thank you, and everyone, please stay healthy, and hopefully before too long, once it's safe, we'll be back to business as usual.
Thank you.
Thanks all, everyone. We wish you the best. Have a great afternoon.
Thank you.
Thank you. To you as well. Bye.